All right, welcome everyone to our webinar, IP Basics for Early Stage Companies, presented by Early Growth Financial Services and Bend Law Group. My name is Jason Kennedy from Early Growth. I am your moderator for today. The webinar is going to last for about an hour, as is per usual for our webinars. We'll have a short Q&A right after the webinar as we conclude. If you do have questions, please use the questions section of your GoToWebinar control panel. Throughout the webinar and of course at the Q&A period, I'll be reviewing questions and asking those questions to our panelists as time permits. Any questions that we can't get to during the webinar, we will of course follow up afterwards to make sure your questions get answered. So without further ado, I'd like to introduce our panelists for today. Tucker Cottingham, our small business and startup attorney from the Bend Law Group. Tucker, thanks for joining us.
Thank you, Jason. So as Jason mentioned, I'm an attorney at the Bend Law Group. We're a small firm based in San Francisco, and we focus on helping entrepreneurs start and grow their businesses. And so among other things, I manage our intellectual property practice, which you can learn more about at blgtrademarks.com. And so the purpose of today's webinar is to talk about intellectual property concerns for early stage companies. And so we're going to go through some of the best practices for selecting a company and product name and discuss how to register intellectual property. We're going to be specifically focusing on trademarks, but we'll also touch on copyrights. Go ahead and get the first slide here.
I realized I wasn't showing the screen. That was my apologies. You should be able to see it there, Tucker.
No worries, no worries. Okay, great, got it. Sure, so starting out, we're talking about what are trademarks. And so trademarks are source indicators. So they're recognizable signs, designs, or expressions that identify the source of goods or services. So for your early stage company, these are things like your company's name, your company's logo, if you have a special pattern or sound or some kind of symbol that's going to create association with your existing customers or potential customers, where they know that when they see this symbol, your company is behind this symbol. This is really important, sort of ground floor brand development. So some sort of common examples of trademarks, just to drill the point home here. You know, the Nike swoosh, when you see that symbol, you know you have an association with that symbol. You know that brand, and it stands for something. The same would be true with the Apple or Coca-Cola. So each of these companies obviously spend a lot of money on branding and marketing, spend a lot of time and energy, and the way that they sort of secure that association through these symbols is through trademark registrations and through trademark rights. So when you're thinking about branding, early branding for companies, there's really two prongs. There's trademarks and there's copyrights. And again, trademarks are source indicators. We register those on a federal registry, and they're the symbols that your consumers are going to be seeing. And then we also have copyrights. And so copyrights is another form of legal protection. It's a federal statute, and it protects original works of authorship that are fixed in a tangible form of expression. And so what this means is that if you create, for instance, a logo that's unique, and you place that logo into, put that into ink, and it's in a fixed medium, then you can register that image as a copyright as long as it's something that's unique that you've created. Typically, when we're talking about early companies, we're more concerned with trademark registration for names and logos than copyright. Copyright rights vest without registration. There's benefits to having registration, and we'll get into that a little bit later. But we're going to focus initially on trademarks. So if we move forward here into thinking about we're at the ground floor, starting your company, thinking about IP, maybe you've already started your company and you're just thinking, okay, I haven't really done anything with my intellectual property yet. Do I even have intellectual property? Most basic form of intellectual property that you may own is your company name or your product name. And so, starting at the beginning, when you're choosing a company name or a product name, there's some best practices that we would recommend. And so, to give you a little bit of additional context, our firm helps launch well over 50 new companies a year. We've advised several hundred companies around the Bay Area and the country and the world, and people coming from different countries. And this is a question we get all the time. We're trying to come up with a new company name, either trying to come up with a new product name, and what should we do in deciding this name? We've hired a fancy branding firm. They've put together this this book for us. And a lot of times people will kind of move on to that next step without taking the initial steps of screening the potential company or product name. So we always suggest that you start out by just performing a basic search. So take the name that you're planning to use and try to figure out if somebody else is already using it. Sounds simple, but you'd be amazed at the amount of instances that this is not actually that this step's never taken. So basic things like search Google, search Bing, search other. You want to search a couple of different search engines so you can kind of cast a wider net. And type in, the name of your product or company with the product name or product description or company, description. Try to figure out if there's anybody just on the internet that's using this name. And then you want to go to actual databases. So you're going to want to look at your, if it's a company name, you want to look at your state's list of registered entities. So, for example, in California, you can go to the Secretary of State website. There's an entity search link. You're able to search the database of registered companies. You need to search based on what type of company it is, so whether it's an LLC or a corporation. You want to search both, and just type in your company name. If it has an S at the end of it, maybe you leave off the S. Try to cast a little bit wider net. And the reason here is twofold. One, you want to know if anybody's using this name because they may have what's called common law rights for that trademark. Additionally, states and counties and cities will reject applications that are already existing, that are trying to register company names that already exist. And so, this is not only sort of a practical branding step to take, but also logistically, if you send in your articles of incorporation or your registration with the county for a fictitious business name, if there's an existing conflict that's using the same name or it's very close, they'll reject the application. And usually you don't get your filing fees back. So you want to think about this in just layers of government. So, you want to look at the state government, you want to look at county government, you want to look at city government. And usually those entities have some kind of searchable database where you can look up company names. The next thing to check is your domain availability. As we all know, it's getting harder and harder to find .com domains. Whois.net is a great place where you can search domains, you can see who owns it, and you want to be cognizant that even if you can have, a one-off, sort of put a hyphen in there and that name's available type of thing, that can create a conflict for you down the road. And so, best case scenario, you really have a clear domain to use, and that's a big part of choosing a successful product or company name. You can always buy domains down the road if you're successful. You can oftentimes buy a domain from somebody, but if you have your druthers, it's nice to start on firm footing. Then the third step would be, after searching government databases and searching search engines and then looking at the domain, you want to look for actual trademark conflicts. And so the federal registry is operated by the USPTO, the U.S. Patent and Trademark Office. And they also have a free searchable database of registered trademarks. And so the link here, the test database here, the Trademark Electronic Search System, has a lot of different levels of complexity, but there's just a basic search that you can type in the name and see if something comes back. You can also search by the registrant if you want to know if another company, what trademarks a company has, or for instance, if you want to see, how did this other company describe their trademark? You can find out that information as well. But you want to look, once you kind of get an idea that you're not finding very many conflicts on the internet or in the state databases, you have a good domain name, then you want to actually look at the trademark electronic search system and see if there's a trademark registered. And we'll get into this in more detail, but essentially you can just know that at the outset. If there's a direct conflict, it still may be worth contacting an attorney, because it doesn't automatically preclude you from using that name, but it's a good thing to know at the outset. Great. And so then, once you have an idea of the potential conflicts that exist in the world, you can take it one step further, and we always recommend clients to do this, although there are certain instances that I will admit do not make sense for clients, especially if you're extremely bootstrapped and your product is not a consumer-facing product. But you can order a comprehensive trademark report. And so these are reports generated by third parties. They're very thick. They're usually several hundred pages, and it's a long list, comprehensive list of every possibly conflicting mark. And they'll search state trademark databases, federal trademark databases, and oftentimes common law, which would be unregistered marks. The reason that a third-party comprehensive search is valuable to you is because the test for trademark infringement is likelihood of confusion. And so that's a really key concept I'll just repeat. The test for trademark infringement is likelihood of confusion. And so if you have a name for your company, Nike, it's spelled N-I-K-E-Y, and you search and you don't find anything that's registered N-I-K-E-Y, but you're a shoe company and there's a Nike N-I-K-E, the likelihood of confusion is very high that when somebody's talking about your product and the shoes that you make, that potential consumer may think that somehow you're related to Nike, an existing brand that's got registered trademarks. And so sight, sound, look, and feel are all going to be taken into account when evaluating a potential conflict. And so, as mere humans, it's hard for us to think of every potential combination when we're searching to find the different combinations of things that could be close to the names we're thinking about. And so these algorithms, these computer algorithms, are able to pull lots of combinations of different endings of words, phonetic parts of words that are similar to another, and put together a nice comprehensive report. Typically, an attorney would then review that report. You would want an attorney to review that report. And if you can get them to write a letter, an opinion letter based on the strength of your mark, evaluating the strength of your mark, that's going to be helpful to have going forward. We really find this to be most useful for companies that are, say, for example, fashion companies, for companies that are about to roll out an expensive branding campaign, or they're going to be having their name used widely in the public realm. Things that are where you're about to invest a lot of time and resource, and you want to be really sure that there's no conflict. So, one, comprehensive trademark reports are important because they identify likelihood of confusion. And the second reason is that the trademark application process can take 8 to 10 months. And so you don't really know at the outset when you apply for your registration of your mark, you don't know whether that's going to be successful. And so this is a way to really limit that risk and to get a good idea of the potential likelihood of success of your application, because you know the world of potential conflicts. Startups move very, very quickly, as do small businesses, and so 8 to 10 months before you know whether your company name is truly protected and going to be owned by you without issue can be quite a long time. And it's never been my experience that a company would wait to get that final registration before sort of moving forward, at least in this current climate. And so then finally, once you do this kind of basic steps where you're screening for potential conflicts and you're searching the trademark database and you're ordering a comprehensive trademark report if it makes sense, and you've gotten a good collection of data for conflicts, it's really worth it just to go talk to an attorney. There's several different kind of moving parts to evaluating a trademark strength and the likelihood of success of your registration. And the more kind of you can put together before talking to the attorney, the more efficient they'll be, and the lower the cost will be for you. But it can really be the difference between quite a lot of money. To give you some idea, so the trademark filing fees for the USPTO are typically between $275 and $325 per class, and you may register a mark in multiple classes. And if it gets rejected, then you're not going to be getting those filing fees back. So always good to consult an attorney. Great. So let's talk about how to register your intellectual property. So now you've identified the name, the company name, or the product name. You've done your due diligence. You've searched all the right databases. You've talked to an attorney. They've said, we think it's clear. Go ahead. Green light. And now you're thinking, okay, so now what do I do? Or maybe you've already done that and you've been operating your company's, you've got users, you've got clients, but you've never actually registered your trademark. So what does that mean? So that means that there's state registration and there's federal registration. And we're going to focus on federal registration. And the benefits of federal registration are that you're presumed to be the rightful owner of that mark in the entire United States. And so in order to qualify, you have to have used the mark in interstate commerce. Luckily, the internet is a interstate commerce. You can advertise goods and services and sell goods and services across state lines over the internet. And so any business that's on the internet can generally show that they've engaged in business across state lines. That qualifies them for federal protection. And again, the benefit is that you're presumed to be the rightful owner. And so I'll just drill into that a little bit further. When you're presumed to be the rightful owner, that means that the court is going to think that you are the rightful owner. So it's pretty self-explanatory. The way that works out in practice is that if somebody sends you a cease and desist letter and says, hey, you're in conflict with our company name, but you hold a federal registration, the presumption that you're the rightful owner places a burden on the other party. And so now that other party has to mount evidence showing why you're not the rightful owner. Very often that evidence will have to be shown to a court of law. That can be a very expensive process. And so the practical effect for early stage companies of these trademark registrations is that you place the burden of proof on the other party that would be the challenging party. So I think that sounds a little bit complicated, but it's very meaningful. It's very meaningful for a lot of our clients early on to know that they have that presumption. A lot of other small businesses don't want to spend the $15,000 to $20,000 going to court and mounting their evidence and proving to the court that they used this mark first.
So Tucker, I've got a question that came in kind of around this topic. I figured I would jump in with here. I know we're not going to jump too deep into the state registrations, but is there an overarching reason or a theme around registering only within a state rather than federally? If you're only working within your state and not presumably selling online or doing anything over interstate wise, is that the time to look at just a state registration?
Yeah, that's right. So there's a couple of reasons why a state registration might make sense. One would be if you're a retail store, you just don't sell goods online across state lines, then you would qualify for state registration if you haven't actually used the symbols in interstate commerce. The other reason that people sometimes look at state trademarks right now is because maybe the industry is not federally legal, but maybe it's legal within the state. And so the most common example there would be medical or recreational cannabis use. And so there are some instances where a state mark might be viable to protect goods and services in, say, medical or recreational cannabis, but that wouldn't be able to be registered on a federal level because it's still illegal federally. Now, I should say that with regard to cannabis in California, the Secretary of State who manages state trademarks is not allowing cannabis-related trademarks. They're following the USPTO's stance, but the USPTO is dictated by statute, and the state rule is just an administrative rule. So the Secretary of State could decide at any time, and I think it's very likely that they will, that that they're gonna change their policies internally and allow for the protection of medical or maybe soon recreational cannabis trademark registration. And we would see a big movement, a big flood of trademark applications in the state that wouldn't be viable applications at the federal level.
Okay, great, thanks.
Yeah, absolutely. So those are kind of some of the benefits and differences between state and federal marks. And so then to actually put together the application, you kind of go through a decision tree. And again, and any attorney, any trademark attorney would be able to help you with these steps, or they should be able to. Certainly our firm, blgtrademarks.com, we're able to help you through this process. We filed over 100 trademark applications with the USPTO. But you want to think about, are you using the mark, are you not using the mark? And so there's two different types of applications. There's an intent to use, and there's an in use. And so the nice thing about the intent to use is that it puts your flag in the ground, so you can tell the world, we're planning to make this amazing flying bicycle. We don't actually have it yet, but we're planning to use it. And so anybody else that's thinking about making flying bicycles, is now on notice that we're planning to use this name. So again, that's the principle. And then in practice, if you file that trademark and somebody else comes in after you and files a second application later in time, they're blocked. Their application is held up while the USPTO decides what to do with your application. And so the rule is, with an intent to use, that you need to submit a specimen. You need to show proof of use within 6 months. And if you aren't able to do that, you're able to extend it. You're able to extend that period of intent to use for another 6 months, and you can even extend it again. So you should have a bona fide intent to use the mark when you file the application. That's one of the rules, but obviously things happen, and so you're not going to lose the application if within 6 months you're not able to get the product to market. You don't need as much evidence early on. You don't need the specimen early on for the intent to use, and so it can be completed a little bit more quickly. Very often it's the same sort of price because you need a lot of the same information to register in the proper classes, but it can be completed a little bit more quickly. And then also the examiner who receives the application can look for conflicts with the information you've given them, so you can kind of get the application process started. If you're already using the mark, you've been using it, then you can apply for an in-use application. And when you apply for an in-use application, it's assigned to an examiner. The examiner works for the USPTO. It's a real person. It's an attorney. They get the application, and they start looking for conflicts. Usually you'll hear back in about 3 months that it's been assigned to an examiner, and the examiner will say, yeah, we're moving forward, or hey, we're concerned about these possible conflicts, or hey, this sounds descriptive. There's a number of sort of rejections that they can give you. The important thing to know is that you can't register a mark unless you're using it in commerce. So even though you can file the application for intent to use, you're not able to actually receive the registration unless you're using the mark in commerce. And so, that makes sense. Just to take a step back and think again. Trademarks are source indicators. So these are symbols that are representing the source of a goods or service. If we allowed everybody to protect all of these symbols that they hope to use one day to protect their goods, companies would just completely fill up the field, right? There would be no room left. And so the idea here is that once you've actually developed a meaningful relationship with your customers or potential customers, when you've used the mark in commerce, you've attempted to either advertise or sell goods in interstate commerce, then the government gives you the protection of, okay, now you're eligible to register this. So you can only register marks that have been used, but you can start your application when you intend to use it, and that can be a big advantage to doing that. So, okay, so you determine whether or not you're going to do intent to use or actual use. Now you have to think about what's the scope of protection. And so you don't get to to just use the name for any purpose or any goods or any services in the world. You have to actually identify how you're using that mark. If it's intent to use, you have to identify how you plan to use it. And then you have to support those planned uses with actual evidence of actual use. So when you're thinking about trademark, you're thinking, okay, what do we actually do? Do we sell bicycles? Do we make shirts? Do we print things on shirts? Do we provide consulting services? What type of consulting services do we provide? And so really, this can be an area that's very confusing to people. The USPTO has divided up the world into 42 different classes. Each class represents a group of similar goods or services. And so, you may have manufacturing of solar panels maybe in one class. You may have, installation of solar panels would be another class. You may have manufacturing of LED lights would be another class. You may have designing a solar panel installation system would be yet another class. And so, you really need to identify first all of the things that you're going to do, so all of the services that you're planning to provide or that you do provide, as well as all the goods that you're planning to sell or that you do sell. Start there, just plain English, and then maybe kind of go to the outer edges, and also we're kind of getting into this area. We're doing downloadable software, we've got cloud-based software, we're also doing a mobile app, we're working on a mobile app. So don't even worry about the classification system. Just kind of think through what your services are. And then either talk to an attorney to help you place those into the actual proper classes, or if you wanted to get on the internet and help to identify yourself what the applicable classes are, you can map those classes to your symbols. You want to be really careful here because these class definitions will affect your scope of rights. And so you do want to be aware of and really take some time to be thoughtful about how you're using the mark and then what classes you're registering in. And again, each class has associated fee. And so, you're talking about $300 or so, more sometimes for each class. And so you don't really want to just say, well, we do stickers and we do coffee mugs and we do t-shirts and we do keychains and we do USB drives and we also, all of that kind of stuff. That might be 5 or 6 different classes. So, depending on, the amount of resources you have and your priorities, you want to just be thoughtful about this process. So, first you identify intent to use versus actual use. You make a decision there. Then you just determine what the scope of protection you're going to receive is or you're going to apply for. Those are going to be mapped to different classes. Then you actually file the application with the USPTO. It's assigned to an examiner. The examiner receives the application. Again, usually you'll hear back in about 3 months or so. And they'll evaluate it. And they'll say, it's too descriptive. It's generic. And so if you're descriptive or generic, you're not able to register the mark. Or they'll say this is confusingly similar to another mark, and they'll send you that letter, and they'll send you a letter called an office action letter, and it'll be a refusal, and they'll say you've been refused. If you applied in 3 classes, you may only get a refusal on 1 class. They may say the specimen that you showed, the proof of evidence of you using this in interstate commerce is not good enough. It doesn't have the mark in it. It doesn't have use of commerce. It's just a logo. So they might have different rejections, and you want to respond to that letter professionally and using case law to say, this is why we can overcome your rejection. So you kind of have this opportunity where they'll make a rejection, and then you have the ability to respond to that rejection and persuade the examiner to actually, allow your application to go forward. Or in some cases, you may need to amend the application. You may have tried to have, wording that allowed you the broadest scope possible, and they say, hey, really, this kind of wording brings in this second class that you didn't actually register for. So that type of exchange is pretty common. They're called refusals, but very often there's a path forward. The nice thing about the USPTO is they're not your enemy. They're not trying to kick out applications. They're trying to help register really solid applications. And so they can be helpful. Also, they're people, so you could have the same application go to 2 different examiners. They probably wouldn't agree with this, but it's true. Is that you could have the same application go to 2 different examiners, and they could have different interpretations. And so, so there is an aspect of sort of human persuasion involved here. And so you can respond to the office action, and then they may reject it again, and that would be called a final office action. So essentially, you get 2 opportunities to try to overcome their rejections. And then if you can move forward, then they would approve the application for publication. So they would say, okay, you've overcome any objections that we have, and now we're going to publish your application in the official Gazette. You have a 30-day opposition period, where the official Gazette is a public journal. Not a lot of people receive it or read it. It's very, very long. It's published, I think it's published weekly. And so you would have the list of all the marks. And so companies that have trademark monitoring services are aware when a mark's published in the official Gazette. They have a 30-day period where they can officially oppose that registration. So somebody can come out of the woodwork and say, hey, for whatever reason, your shoe company called Nike, N-I-K-E-Y, got through the examiners and is now published for opposition in the official Gazette. And now the attorneys from Nike are going to say, hey, wait a minute, we just received a notice that this application might infringe our application, so we're going to oppose this. If they oppose it, then you have the opportunity to go back and forth. You can do that. Most often that will happen outside of the USPTO. You'll receive a letter outside of the formal proceeding and say, hey, let's handle this between ourselves. In some cases, it'll go through the formal opposition process. If nobody opposes the mark after that 30 days, then it's moved for final registration. There's about a 3-month period of time after the opposition period closes before the final registration is approved, and you receive the certificate. But then you will actually receive a paper certificate. Typically, this is 8 to 10 months now from the first. If everything goes smoothly, it's 8 to 10 months from the first application date. And then once you have the certificate, then you're officially listed on the USPTO Federal Registry, and you have that legal presumption that you're the rightful owner. Then you have the burden on the other party. One thing that's important to note is that by registering your mark, you're not always going to be the rightful owner. So the presumption is that you are. But in the United States, we have a priority-based trademark rights system. And so that means that if somebody else has actually used this mark in the same classes of goods or services as you, they may have common law rights that trump your rights, even though they did not register their mark and you did. So going back to this, my favorite example with Nike, if you have Nike and everybody knows Nike and they sell 1 million shoes and they make sports gear and everything else sports related, and they never filed trademark registrations for whatever reason, they just decided not to, and you go ahead and you register Nike, N-I-K-E, for shoes, they would be able to come and oppose your mark, and they would be able to say, even though we never registered anything, we've actually created this relationship with our consumers, with our customers and potential customers, where they associate our goods and services with these symbols, with this word Nike. And that association is so strong, and we've been using it in time before you have, that we can come in and actually trump your registration. Now, they would have the burden of putting that evidence together, so they'd be showing, what their actual sales are, what evidence of followers online, how much they've spent on marketing. They would put together a package of evidence, but that would probably be a persuasive package of evidence. And so you don't get once you have your registration, you get that presumption, and anybody that comes after you, you have a right, you have trademark rights that trump theirs. But people that came before you in time, depending on their actual use and their scope of use geographically and relative to goods and services, they may be able to attack your registration still. So something to keep in mind. we can go to the next slide here and talk a little bit about proper use. So once your application has gone through the USPTO process and you've received your certificate and you're registered, then you can use the R with the circle that we all see so often. Quick note, before you use the R, you can use the TM. Top of the company name says TM, trademark. That doesn't mean that they're registered. That means that that it is being used and that they're asserting what we call common law rights. Common law just means it's not registered. It's being used. The R means you're actually registered. And you can also say here, registered in the U.S. Patent and Trademark Office, or this abbreviation here, which stands very clearly for registered in the U.S. Patent and Trademark Office. So you wanna put these symbols showing that it's a registered mark on your marks. You want to let the public know that you have this property that's yours, that's registered property, that's been acknowledged by the U.S. federal government. That's very important that you do that. We're talking about intellectual property, and so these are property rights. And so the way that property law works in the United States is that your property rights can be eroded. So there's a thing called adverse possession in the law. If somebody goes and camps out in your backyard and lives there for 10 years and you see them every day and you never say anything to them, you never tell them they can stay, you never tell them they have to go, eventually part of your yard can become their yard. So that's this idea of, you've got a neighbor whose fence is there, and they've had this fence in your yard for years and years and years, and you never said anything to them and never paid attention, and over a certain amount of time they can actually erode your property rights. Well, the same thing happens in intellectual property. So if you are not making an active effort to defend and protect your property, over time your rights can become diluted, they can become weaker, and you can eventually sort of lose or start to erode your scope of protection. And so that gets us to the next slide, policing the mark. So now you've got your registered mark, you've got your R with a circle on it, you've got your federal registration certificate, you're out in the world using it to represent your company and your brand. You've created this amazing association with your customers that you've spent money on through marketing and branding, and now you have to police your mark. So what I was just talking about, adverse possession, the ability to lose property rights over time by not standing up for your rights, basically. You have a corresponding duty to police your mark, and so that means you need to monitor how your mark is being used in the world. There are trademark monitoring services. There's not a law that says you have to have trademark monitoring services, but it's a very easy, fairly low-cost, convenient way to keep track of what's happening in the world with respect to your particular intellectual property. And so, this would tell you, for instance, somebody's registered, application, or somebody's filed an application and they're in opposition period. Ding, you get a notice. Some company in California registers a name very similar to yours in the state database. Ding, you get a notice. There's other kind of aspects to these trademark monitoring services, but the idea is that you want to be able to show a court if anything happens that you've been active, you've been aware, you've been telling people, you're not allowed to use this. And the way that we most often police marks is we send letters, often cease and desist letters, which I'm sure you've heard of, that say, you are not allowed to use this mark. You need to cease using the mark. You need to desist from further use of the mark, and you need to, depending on the circumstance, do a number of things. Maybe pay the legal fees that it costs to send you this letter. Maybe to pay us some kind of penalty because you've been using it for a long time. Maybe you need to, change your name and never use this again. Or maybe you have a coexistence agreement where you say, hey, we're not really too worried about you, but here's some fencing, and these are the only things you're allowed to do with this symbol, because as soon as you pass this threshold, then you're in our territory. And so, those are called kind of coexistence agreements. And so there's a lot of different ways that people can police their mark. There's a lot of different strategies, hyper-aggressive, fairly cooperative. There's informal ways of sort of dealing with the issue. There's very formal ways of dealing with the issue. And so, the strategy, there's a lot of different strategies and pros and cons to the type of enforcement strategy your brand chooses to adopt. But the universal principle is that whichever strategy you adopt, it needs to be a strategy, and you need to police your mark. And so so that's sort of the life cycle of very basic kind of brand protection trademark law 101 for early stage companies. So I think I want to just kind of pause there, and Jason, I don't know if we have any questions from the audience, but we can kind of move to some questions and see if anybody has any finer points they want me to elaborate on.
Yeah, thanks, Tucker. This was great. Just a reminder to everyone, you can use the questions panel over on the side of your GoToWebinar control panel. So we've got some questions coming in, but I encourage you to get yours in if you haven't already. So we'll run through a few of them here. We've got a little bit of time. Should one register a DBA, their legal name, or both?
Sure. So a DBA is doing business as, and that's a fictitious business name where you register usually on a county level, and it allows you to both deposit checks under whatever DBA you've registered and hold yourself out to the public using maybe a different name than the one you registered with the Secretary of State. So that's the DBA, and so sometimes somebody will start a company under one name, and then they'll change the name, or they'll create a product that's under the same company name, and they'll register a DBA. You want to think about trademarks, again, going back to this representation. So these are source indicators. And so if you're selling a product and you're using a symbol, and if that symbol's been registered as a DBA, then you would want to register that symbol with the USPTO or the state trademark Secretary of State in California, relative to those goods and services. So if you're using a DBA and you're using your company name to sell services, goods and services, then you would want to register both. If your company name is never been seen by anybody, it's a holding company, and it's just for tax purposes, and the only the only symbol or name that you're actually selling things with is your DBA, then in that case you would probably only need to register your DBA because you wouldn't be able to provide evidence of interstate commerce with the company name if you've never actually used that name to create an association and sell goods or services. Does that make sense?
Okay. Yeah, that's great. Another question here. I think we touched on commerce earlier when we got into the discussion specifically about trademarks. What is the definition of commerce? Is it that a company has received revenue, spent money on marketing? How different from just having a logo? So as far as trademark law is concerned, how is commerce defined?
Sure. So it depends on what class you're registered in. And so if you're a services class, which is usually class 35 and above, then you can oftentimes show evidence of advertising your services online, interstate commerce. If you're selling goods and you're one of the goods classes, then usually it's a sale or the ability to sell. So you want to have a bona fide use in interstate commerce, and so the easiest way to kind of think about it is if it's goods, you want to have an actual sale. If your services, an advertisement for services may work.
Okay. Can you or should you register a unique product name, even if it is not a design but just a unique name?
Absolutely. Absolutely, yeah. If you're going to use the name to represent the things that you do for money, whether those are selling things or providing services, then that name should be registered as a trademark. That name is a trademark, and so if you have a trademark, you should probably register it.
So what happens when a seemingly defunct company owns the trademark that I want?
So you want to look at the registration. Good question. This comes up a lot. You want to look at the registration, and you want to determine if the mark is still in good standing. So you have certain maintenance requirements to keep your registration active. And in some instances, that mark may become abandoned, or that mark may get canceled. And so you first want to just see, is the mark in good standing? That'll make a difference. If the mark's active, good standing, but the company seems to have gone out of business, no longer using the mark, then you do have some options. You should talk to an attorney about what makes the most sense, but potentially you could try to acquire that and get the mark assigned to you. You could potentially file some kind of proceeding with the USPTO, notifying them that, hey, this mark's no longer in use, and we want to challenge the protection that it's receiving. So obviously the second option may be more involved, but depending on what it is, it may be the better strategy.
Okay. Let's see, another interesting question. We have a long-term goal of international expansion. How different will this trademark application process be for countries outside of the U.S.?
Great question. So, and right now, international trademark protection is more relevant than it's ever been. Companies are becoming international companies, quicker, especially in the startup world, where you see a startup launching in the U.S. and there's essentially a identical startup popping up in another country very quickly thereafter. There are, organizations that essentially that is their business model. And so international trademark protection is becoming more and more important, definitely the case for our clients. And the application process, it depends. There's a Madrid protocol that allows you to essentially use your USPTO application, and that same information can be used for a bunch of countries at one time, to apply for protection in a bunch of countries at one time. Depends on not every country is included in that treaty, and so depending on where you want to register, it may be very similar. The filing fees are going to be a lot higher, and the application of saying we want to use this Madrid protocol to register in these different countries can be complicated. So to give you an idea of filing fees, we often will register international trademark protection. That costs $5,000 or more for those government filing fees. That's not money that goes to us. That's just actual filing fees. So it's a more expensive process, and it requires some knowledge of international law in the various countries that may be members to the different treaties, but you can use a lot of the same information that you use on your USPTO application. So sort of a roundabout answer, but hopefully that's helpful.
So I have a question myself from my prior experience working with a company that was looking to expand internationally. There was a time where I was receiving solicitations from somewhat shady characters over email wanting to register or sell me the trademark for a particular European or Asian country. So I have to imagine I treated them like they were scams, but are there any times where those are actually legitimate, or should, if founders and entrepreneurs are getting those same emails, should they just kind of, throw them in the spam folder?
Yeah, you should be very, very skeptical of any unsolicited email that you receive that says you owe fees. So the biggest issue that I'm seeing right now is a lot of our clients are getting letters in the mail that say, hey, you filed this international trademark application, and now you owe us $1,500 to, one of the countries that you applied to, the Czech Republic, and you need to pay this by within 30 days. And because the fees are pretty high, and because there's a lot of moving parts, unfortunately, some people just pay those fees thinking, this country requires this additional step. Those are oftentimes scams. The letters to say, hey, buy this mark, if there's a clear conflict, then you should receive official correspondence notifying you of the conflict. So if you haven't received that and you receive an unsolicited offer, may not be bogus, but chances are it probably is.
Okay, great. Another question here. I am looking to put together a founder's agreement with my co-founder. Should trademarks and copyrights be part of this agreement?
That's an interesting question. So if you're going to be co-founders, one of the things that we always do, so our law firm does more than intellectual property. You want to address the intellectual property rights. You want to essentially, assign everything that you do related to the purpose of the company that has corresponding intellectual property. You want to assign that property to the company. So to the extent that that may be trademarks and copyrights, then yeah, that would kind of be covered. In terms of, founders agreements are pretty open-ended agreements, so it could be you're in charge of managing the IP registrations. That's one of your duties as a co-founder. That could be in there, but usually we see it in the form of both parties agreeing early on to assign all IP and saying if there's stuff that you're never planning to assign to this company, if there's inventions that you're still working on, outside of our venture, then this is the time to kind of bring those out and talk about them and put them in the agreement as well.
All right, I think we're going to do one more here. It's an interesting one and one that might put a scare into anybody that hits this scenario. But what happens if you get a cease and desist for your already registered trademark? So
Very good question.
Yeah, somebody comes looking for you, making maybe a dubious claim for your trademark.
Yeah, so usually cease and desist letters have a response deadline, so you probably want to talk to an attorney pretty quickly. One of the reasons is that there's oftentimes attorney fee provisions in the cease and desist letters, and if you don't do anything and then they file a lawsuit, you could be on the hook for some penalties or some fees. But the presumption again is that if you have a registration, that you are the rightful owner of that mark. If another party who is not registered wants to challenge your registration, they can do that, but they would have the burden of putting that evidence and argument together, and they would need to have the facts that support it. And so that would be things like they've been using it, earlier in time than you. They have this demonstrated scope of use that they can, verify and validate. And so it may be, it's really fact dependent in terms of what the immediate thing you should do is. The good answer is probably talk to an attorney. But the presumption's in your favor, and if somebody's willing to spend the money and mount a offensive campaign against you, showing that they have superior rights, trademark rights over that particular mark, then you may be sort of going to the mats.
Do you see that? It's just another one of my questions here. Do you see that working from your side, where founders, startups, very small, early stage companies might be pushed around or tried to be bullied by someone with a little bit deeper pockets? Do you ever see anything like that, where they throw this kind of legal action?
So we see that all the time. The most common example is where a big company has a mark registered in a different class than what you're registering it in, and then they would send you a letter anyways. And so the idea here is, well, hey, there's no conflict. We make roller skates, and you provide, management consulting services, and you sent us this letter. But because you're a big company and you can easily spend, $50,000, you're going to bully us out of using this name. We see that a fair amount. And probably the example I gave was a little bit more different than we see. We see things that are more marginal than that in terms of maybe being on the other side of a certain class description. But I don't see a lot of companies that are well financed that are willing to fight a expensive battle and haven't bothered to register their intellectual property. Usually if a company's in a position to do that, they also are registering their IP. And so it would be kind of rare that you would have a registration and then somebody a big company who had been using it for a long time before you, and was well financed to fight the battle, had never registered it. I mean, it could definitely happen, but we don't see it very often.
Gotcha. All right, we've almost hit our hour, so I think this is a good stopping place to wrap it up. Tucker, thank you for joining us and providing some very valuable insight for us. For everyone that's attended, we're providing a recording of this. You'll get it via an automated email within the next 24 hours. We'll also get it up on our blog on earlygrowthfinancialservices.com here within the next few days, so keep a lookout for that. Thanks again to everybody that attended, and we hope you have a great rest of the week. Thank you very much.
Thank you.